But what we're finding, and one of the things that Robert had said to me is like, what do you think is a topic? I've worked with a lot of the agents from here. And one of the things that I realize is that once we get the contracts, because we check, we'll find out that there's violations. And the worst thing that could happen is when we call you guys up and we're like, look, we got the deal sheet, but did you tell them that they're buying subject to this, this, and that? And many a time when it does come up and it's not on your deal sheet, nobody looked it up or didn't know where to look. So I figured it'd be best if maybe we did one tutorial where you guys could figure out where it is. We don't do magic, but we actually do research the properties for you because, like you, once we commit a seller to sell, then we can get in the lawsuit if we can't get them out of the transaction. And you don't want to call a seller midstream and say, hey, listen, I forgot, we didn't realize that you owe $20,000 in liens and you've got 2 DOBs you've got to clear. So that's the thing that we want to find out before. And you guys want to find out before you even waste your time listing because you've just wasted all this time. So there's 2 things with violations that are super important. Agents love to say transaction as is. Is transaction as is meaning we're not representing the roof isn't going to fly off the top, or meaning that it doesn't matter if the basement's got 6 feet of water, okay? When you say as is, that's what as is for a lawyer. For us, it means as is, we do nothing. So most of your transactions really aren't as is. Their seller is not necessarily responsible for any further repairs other than plumbing, heating, electricity in working order, and roof free of leaks. Those would be the regular representations, right? So when we get a deal and you say as is, we cross out also the violations. Because to us, that means we're not responsible. Seller is not responsible. They're buying it as is. That's not what you guys always mean either. So I'm going to step back 1 second and I'm going to say, how do we put together the deal sheet so that it's very clear to all parties? As is transaction is exclusively if seller is doing nothing. Absolutely nothing. I don't care how many violations are on this property, how many liens are on the property. I don't care the condition of any of the major systems of the property. That's as is. What we can do on the deal sheets is we put seller's not responsible for any repairs, but normal representations, which would mean no violations, no judgments, no liens, plumbing, heating, electricity working, roof free of leaks. Okay? So if any one of you comes across a transaction where now we're dealing with the violation aspect of it, when you're looking at violations, if you tell us property is, the seller's taking subject to violations, be very careful. And I have a transaction now where the other attorney got caught, and it's a deal from here. One thing is to say a violation, another thing is to say judgment and liens, okay, and fines. I'll explain why. If you tell me that they're buying subject to judgment, or a violation, I should say, that means that they're buying subject to the actual construction, the physical labor part of the violation. If you do not say that they're buying subject to fines and liens, the buyer assumes the responsibility of doing the work, but that $12,000 penalty gets paid by the seller. Because you did not say, we call. My office calls you guys. But if you're working with other attorneys, they will not call or may not call. And then you find yourself in a pickle. So if when you're saying we're selling subject to violations, you must specify if it is violations plus penalties and liens and fines. Do you understand? There's a tremendous difference. Today, the example that Robert had sent over to me will show exactly what I'm saying. There's a $12,000 fine on there. If the attorney didn't write it, it's subject to violations and fines, that seller's paying the fine because it's not assumed to be a violation. It is a fine. Is that clear? That is like the most dangerous of all aspects, that you guys get caught if you don't have an attorney that's working with you directly. So you want to be careful with that. These ECBs first start out as a violation with a fine. After that fine matures, it becomes a judgment. Once it becomes a judgment, it becomes a lien. A judgment is a lien on the property, right? Once it's a lien, if we don't specify it, that's a monetary obligation. Sellers are always responsible for monetary obligations unless we carve them out of a contract. So just to brief it, because it's a lot. If you have a seller selling subject to violations, always put Buyer's sale is subject to violations, liens, and fines. Always, if that's not the case, always. That is something you should write, never forget. Because if you're not working with my office and the other attorney does not put that in, you're going to pay for them. We have a transaction now where I put it in and I put them in it all the time because I don't want to ever get burned. And this was a mistake. I think that it had been negotiated wherein the seller was going to pay the monetary aspect of it. But when I see a deal sheet that comes in, my office knows if it says violation, automatically insert fines, liens, and penalties because we're not going to get burned. I'd rather go the other way, but later than not to have to explain to a seller how I messed up a contract. So on this particular transaction, I feel horrible, but they signed it. It's there. And there's a lot of monetary lien on this property, and the attorney agreed to it. Normally, that's something we could have negotiated. But be careful. Be wary when you speak the language, okay? The language should be clear with respect to violations. There's 3 searches that you go to. You do DOB. Now, DOB has the business information, building information system, BIS. They also have DOB now, okay? So where we get caught now is with DOB now. Why? We've always been using the older system. When they created DOB now, what they actually did is they went through DOB databases and they threw a bunch of crap onto the system. So DOB now hurts us in that it's picked up minor alterations. Whenever we have a deal that's got an issue, it's a minor alteration, meaning that the property had work done, got an approval, got a C of O, but in the midst of all that, there's little minor alterations that get signed off. Because they were still showing open on DOB paperwork, DOB now brings them all up. So now it becomes a real pain because we're finding ourselves having to go and find the old electrician, the old plumber, that all they have to do is literally click a button on the computer to close off that alteration because the C of O is already there. But that becomes such hard work, and it's easier if it can be avoided, meaning we do it beforehand. The minute you take the listing, you pick it up, you get that addressed, so that you don't spend time and angst looking for this, because now you have a seller that you've put into a transaction. You got no way out of this deal. We got to get this done. And it just becomes uncomfortable. It's much easier to let the seller know the minute after you've taken your listing, sign it first. Then we talk to them about the situation that we've got to get cleared. Okay. And that's what you do. So DOB now is awesome to look at because 99% of the time it shows nothing open because it's a newer system. But the one time that it does, it's brutal. And I've gotten hit in a couple of those. So DOB is 2. So like we'll do the DOB search now. All right. So if you just, I just do DOB, like, I type in DOB and it'll bring me on mine. Yeah, because I do use it. So you come down up to here. This is what I was talking about. See how you have DOB now here, and then you have the BIS system, the building information system. This one is the one you start off with and it's the BIS system, building information system. So for DOB, you would put DOB and then business information system. That's your first search. And if you put those things in, you'll follow yourself through. Like, you don't have to stress it. And guys, you all have my email. And if you don't get my email, you're more than welcome to shoot me an email, call me. It's like, there's no obligation. The objective is to make sure you guys do it. Your property was Brooklyn 222 Essex, wasn't it? Yes. Oh, yeah, Essex Street. Yeah. All right. Yeah. All right. There we go. So it's just going to require the county, the address. So when you see a huge red line on there, you know that there's fines on this property. This property has penalties. All right. So there's DOP penalties and fines that are due. The way I search, I first look for a C of O. First thing I always do is see if a property has a certificate of occupancy. In this particular case, it doesn't. That doesn't mean anything. It means that it was built prior to. The requirement is a CO. So right up on the top right here where I'm at is where you would see your C of O. You see that? Click there. Always start to make sure if the property does have a C of O. And then you come out here. It's got complaints, violations, things like that. Complaints are not violations, and they really aren't going to affect your transaction. I highly recommend you look at them. I look at them. Why? Because those are the things I want to alert my seller to when I speak to them, because I already know what they're looking for. I already know what DOB suspects on the property. And the last thing I want is one of those complaints becoming a reality during my transaction. So I look to see if they're recent. If they're recent, I alert the seller. Listen, be very cautious. They're looking for you. This is what they're going to come out looking for, so that you can prepare the seller You don't want to leave them blindsided. Most sellers don't even know that there are complaints. So in this particular case, these complaints are 2015, 213, 213, not a reality. As a matter of fact, that helps when I speak because I'm like, listen, since 2015, they haven't done anything. It's 2024. What's the problem? And that's how I can fight off an attorney on the other end. They picked it up. The seller's been illegally converted. Defective boiler at the location. This house did ultimately get a violation for that complaint. So then you see there's DOB violation and then there's an ECB. Remember when I was telling you that there's a part that's construction labor work and then there's a part that's monetary? DOB handles the physical construction labor part of a violation. ECB, same violation, they handle the monetary aspect. So you will get hit with both. One a monetary, one a construction. So when we say subject to violation, we mean the labor, the DOB violation. We are not necessarily meaning the ECB portion of it. That's why it's very important that you speak it properly when you mean to speak it. If you mean that it's monetary and work, then it's violation plus judgments, liens, penalties, fines, whatever language you put in there, but it's got to be monetary, guys. Okay, so this house has the same violation, but it got hit in both departments. So even when you clear the violation off for the work, you have to still go to ECB. And you can go to ECB pay, but you still got a DOB violation open. All right, so this guy's got both of them. On this particular house, for example, here, there's a penalty already, a civil penalty for not responding. So that's $1,500. You click on the violation here. And if you see, failure to certify. So this violation already went 3 times around. What happens is the first set of violations are usually like a $500, then it'll go to $2,500, then it goes to $6,000, then it goes to $12,000, $18,000, and $24,000. So once they get them at that level, this one kept going. Its violation is still open. This was a default, and I'll teach you how to clear these things. I mean, if you really care. But this is a $12,000. The penalty balance is $12,000. They paid $0. So ECB and DOB are both open on this one. If you look up here, this was a default. No one appeared. Okay, on default violations, you have a right to reopen. If you can show a meritorious defense and an excusable default on this is a judgment like any other legal judgment. And the law is if you can prove a meritorious defense, which is a real excuse or a defense that would possibly win, and an excusable default, a reason why you did not appear, the court opens these cases. So on a default, it can be opened. You can show up and say, hey, look, I never got notice. I didn't know. But this isn't the case. It's all done. Here are pictures. And they may open this up. If they open it up, you can fight that $12,000 judgment. That's something that your seller may be willing to do. That's what expediters do, guys. When an expediter lowers their fees, they get lower fines and they'll charge you for that. They're not creating magic. They're physically going in and bringing in an affidavit that shows an meritorious defense, excusable default. Court opens it up, and the minute it gets opened up, it goes right back to its original balance. So they're getting paid 20% of what they saved you because they're going. All right. So if anybody went, it could happen. I don't know. You guys want to go, but see what I'm saying? So it's doable. It's what the expediters do is doable. The seller can do it themselves, and if we can help them early on. Problem is, by the time most of you get this, we don't have time to even talk this way. We're just like, let's get the person that's going to charge the least. Let's get them done. We got to get this closed. We're already caught in the middle, right? So this is where you're at. So this one could be opened if you had to open it. And it's that complaint. They did an occupancy contrary to that a lot of the C of O. They built a bathroom basement and they got caught with it. Now, the only way to get rid of this thing would be, now you need a licensed plumber, a licensed electrician that's going to certify that it's all been removed legally. They're going to want the toilet sealed. In the past, we would just get away with that. Now they want you to put cement into the drain line. And now it's crazy. And then it's even crazier that they walk by with their little detector and they can see behind walls. So you can't even put a wall in front of a bathroom anymore. Yeah, it's definitely gotten intense. So this house in particular has the $12,000 fine. If I go to the other one, if that was on the DOB aspect of it, let me just kick it back. Why am I not going? Does it not go back one more for me? There we go. Hold on. So now if you go to the ECB aspect of it, it's going to be exactly the same thing, but it's just going to show. How do I do the?
You're two in the middle. Just click on the left.
Oh, your thing has a sensitive. Mine has no sensitivity, no right. It's the same thing. It's the erected the bathroom and everything else. But if you notice, it's the ECB portion of it. Okay. And it'll look exactly the same. And if had they paid the $12,000, you'd only see it as a DOB violation, no longer an ECB violation. Okay.
So you're collecting on both sides, Carol?
No, this
Or
is
it's just showing.
it's showing on both. Right. And but that's the problem. You've got see no compliance recorded. So they didn't comply, they defaulted again. But it's if you look at the numbers, they'll correlate. They'll always tell you to refer back to. This is one big chunk here. And then what gets worse is once they're here, if we pulled the title search and asked for judgments and liens, all of these would come out again. Do you understand? Let's assume you're arguing. Oh, but no, but we said no violations. Absolutely, that's a violation. It's going to show up on the lien search because these things are already liens. All right. So that's why it's super important you speak both languages. So that's really where we are with this. And then the other ones are the HPDs. But before I get to the HPDs, now that I'm on liens, one thing that I can't look up and you guys can't look up are sidewalks. But you can, not on these systems. Department of Highways, when they create a sidewalk violation, it's called a sidewalk violation, but it's really a lien. And why do I say that? Because Department of Highways doesn't have a site to create violations. What they do is they place a lien. So when you get a sidewalk violation, it is automatically a lien, right? So how do you find it? On Geodata and Atom. Now they call it Atom. That's where you're finding your sidewalk violations. So nobody should ever be surprised on a sidewalk violation. It's on the Atom. You go in there and when they put the LPs, all the mortgage lien, sidewalk liens are there too. That's how you get your sidewalk liens. So you guys should all be looking at, Atom, I think is what it's called now, to make sure that there are no sidewalks. Okay? Those are super important because they take a long time to get rid of. All right? The other site that we look at is HPD. So there's Housing Preservation and Development. So that would be your HPD search. Let me see if you have HPD online here. There you go. So you just type in HPD. You're going to get to HPD online, and you'll click on it. Super easy site, guys. They just even made it easier. So it's 6th Street, Brooklyn. Hold on. This property has 35 violations. Now, with HPDs, there is no monetary value. These are violations only. There's no monetary value whatsoever. Okay? So on these, all it requires is that the work be done. And the way it happens is, if your client has HPD violations, I would recommend you print this out and you go to the house. You look to see if the work for these violations was done. If it was done, all that's required is them to fill out an affidavit and pay $300. You go to HPD, you fill out their form, you pay $300 in a money order, they'll inspect the property. HPD gets up to 45 days to come to the property. They will inspect. Everything that's been cleared, they'll write off. Okay? There's no reason for these to stay on. These are not, there's no money. It's $300. That's it. It's just a matter of calling and making doing the affidavit and making the inspection. What I'm finding now is that on many of my files, HPD has gotten into houses that are 1 and 2 family. HPD changed the regulations a little bit ago, wherein they only used to be on 3 or 4 families, right? 3 or more families. Then they started to say on 1 or 2 families, if you're not living in it, you also have to register it. So what happened is when you had a tenant in a 2-family house in years past, it didn't matter. They could complain, they could do whatever. It's not HPD regulated, nothing would happen. Now, HPD shows up even on 2-family houses, but sellers haven't registered them because they live there. I don't need to register it, right? So, but HPD is still placing violations. So now in order to be able to get the inspection, you have to file the property. Saying, I don't want to file with HPD because I don't want HPD coming to my house again. And I'm not subject to HPD regulation because I live in the house. And that's where I'm finding a little bit of a problem. And I try to explain to my client, who cares? We're selling, you're leaving. They're like, not doing it. And so I've had some sellers that are really reluctant because the truth is that the law is that you only have to register a 1 or 2 family if you're not occupying it as your primary residence. But the only way to get an inspection scheduled is if you're registered. So those are the things that we would look at, when you have a seller, and we could speak to them. But so that the only thing that's required here is that it be registered and that you pay the $300. He keeps clicking his middle. I don't know. My thing is not middle.
The disadvantage of registering.
Well, what happens is because you don't want to be on their radar. The HPD inspectors, they make a living walking around the streets. Your property is registered with HPD or subject to HPD regulation. All they got to do is knock on the door. They're in, which is horrible, but it is true. So nobody really wants to become part of the HPD program, short of, oh, wow, this thing has a vacate order. Look at this. This particular property. So when you open up the site, the top part's going to tell you, right up in here, it's giving us all the information about, the property. Look, it's a 2-family house. Like, seriously, this is nuts. And then 35, it's got 4 complaints and 35 violations, but then you look at all the different things here, and it's got a vacate order. So no order to repair vacate orders have been issued by HPD since January. However, let's see, no records found. I can't see it. Please contact the borough. So a vacate order, guys, it's basically saying that no one has the right to occupy this premises. So no one should be living in it because of that. People do, but they shouldn't be. And on something like that, only happens, God forbid, if there's a fire or something and somebody gets hurt. This goes from an accident to, unintentional manslaughter or some crap like that if something happened. Yeah.
I'm still shocked how this property is being sold. I mean, with all that.
I don't know, because are we being? I don't know. The buyer's taking subject to everything. Yeah.
Yeah, because we negotiate the price
And they're contractors.
He needs to know how much he has to invest after he buys.
Well, I'm representing seller or buyer. I'm representing the buyer. Oh, girlfriend.
This is a real house. This is from the bank. And we already have an accepted offer, so we're just waiting on you.
What bank are you working with?
I'm not sure now.
Banks can close their eyes to a lot of things because some lenders work with what's called a short title, and another way to say it is they don't need municipals. And in your municipal searches or where your violations, some lenders that can work without the municipals, and many things will go away. This property is going to be a little difficult to many things go away because you're going to show up on the actual schedule of this property. It got hit. Most of this is probably going to be liens up front, which is going to require the buyer to pay them.
Yeah, that's exactly what he needs to know, like to see if it is under his range.
Yeah.
And to see if he
Because some of the things are going to come up as ECPs up at the front end. Yes. Remember that file that I told you I put it in the contract? The lawyer didn't pick it up. I don't know. I feel horrible, but I represent the client. I can't backpedal my situation. The liens on the property, it's Douglas. Another one that we sold it subject to all liens. Marsha Douglas sold subject to all liens.
Meaning the buyer took everything.
Yes.
Yeah.
Yes,
So
he's even going like this because he didn't realize when he said they're taking subject to all violations that I would take it that step further, which I did. I went straight in because I don't play. I don't risk my office. So you don't explain it properly, we're putting it complete. So now these poor people and they're just placed another $300 one on the property and they have to pay for it because the bank's not going to close with it.
Now, does any of this come up like for a property like this where they have a vacate order? What about insurance?
For homeowners insurance?
Yeah.
Yeah, they're going to have a major problem. This is something that an investor would pick up, and then they would get an investor's insurance policy, a construction policy. Right.
I'm sorry, the bank is U.S. Bank National Association as legal title trust.
Yeah, though that's the bank that's selling it,
Mhm.
not the bank that's doing the loan. Who's doing